last case set for argument this morning is Singer versus Singer. It's case number 18CA0073. Both parties are represented by counsel. So each will have 15 minutes to present your argument. Upon may reserve up to 5 minutes, as you know. Let me know and I'll keep track of the time if you are going to reserve time. We have read the briefs in this matter and are prepared to proceed if you are. And a reminder as to matters, if you're going to, we just use initials, not names. And what else, Judge Carter? Oh, you need a sorry. Okay, now we're all set up here. Then.
Evidently, I lost my pencils when we were
Want the other pen?
conferencing. Yeah.
Go ahead, you may proceed. Thank you.
Thank you, Your Honor. May it please the court, my name is Brent English. I'm here on behalf of Gary Singer, who is the appellant in this case. I'd like to reserve 3 minutes of my time.
All right, I'll let you know when you get close.
Thank you. Your Honors, this case has a rather tortured procedural history, as I'm sure you read in my brief. The case started in Medina County. Actually, the case started in the Chancery Court in Tennessee, and then 2 days later, a case was filed in Ohio, and the parties spent about 9 months with other counsel other than Mr. Bailey and myself arguing about which court had jurisdiction. Ultimately, it was determined that the Ohio court had jurisdiction, including, importantly, jurisdiction of the Uniform Child Custody Jurisdiction Act over the 2 children who are at issue in this case. The procedural history was that the case proceeded for an extended period of time, and ultimately the case was dismissed, allegedly for want of prosecution, and it was discovered that the Tennessee case was still pending despite the UCCJBA determination of custody issues being in Ohio. The case then was reactivated in the state of Tennessee. No new filing had been filed, and the parties proceeded to adjudicate their rights and responsibilities in the state of Tennessee. Ultimately, the divorce case itself was granted in the state of Tennessee based upon the settlement that the parties were ultimately able to reach. However, the child custody issues were then transferred back to the Court of Common Pleas of Medina County, and the case began here in Medina County in 2018, where the mom, Marella Singer, filed a motion to determine the custody of the children, followed by a petition for a legal separation filed by Gary Singer, and I won't deal with all the intricacies of those pleadings because I don't think they're really that important when we get here. Anyway, the case was then, these 2 cases were then consolidated for purposes of hearing. The only issue in front of the trial court was the allocation of parental rights and responsibilities. Everything else was resolved in Tennessee with an agreed judgment entry that is part of the record. So at the point when this case came back to Medina County for purposes of that adjudication, the case was assigned to a magistrate, and in relatively short order, the case was set for trial on August 9th of 2018. Prior to that time, at least a month prior to that time, there was a proposed shared parenting plan that was filed by Gary Singer, and an application for shared parenting, as well as a petition for a forensic psychological evaluation to be undertaken by Dr. Stephen Newhouse based upon the results of a deposition that was taken of the plaintiff, in this case, plaintiff being Marella Singer. The court did not rule on that motion, in fact, ignored that motion, and ignored the request for shared parenting and proceeded to trial on August 9th, where the parties were present. My client is a resident of Tennessee. Marella Singer is a resident of a different county in Ohio, although she was a resident in Medina County at the time when the case was filed. There is no dispute about venue, and it would have been waived in any event. So the court heard 1 day of testimony. Basically, my client's testimony was given as upon cross-examination, primarily the issue related to child support, and then Marella Singer was able to testify, although she had not been cross-examined thoroughly. And the court at approximately 4:30 in the afternoon determined that it could not stay any longer, even though it intended to that day, and it have the entire trial that day.
Wait, you said she had not been cross-examined. There's a difference between she had not been cross-examined and she had not been cross-examined thoroughly.
We intended to call her in our case. So we cross-examined her with respect to her basic testimony on certain issues that were raised. We intended to offer a case, including the cross-examination of her with respect to the allocation of parental rights and responsibilities in our own case. So we deferred, essentially, although we did conduct some cross-examination of this witness.
Now, was this trial set for a multi-day trial?
No, it was not. It was set for 1 day, and only 1 day. And the record shows that I, personally, had a trial conflict the next day on a continuing case in Lorain County that had been set for various days in Lorain County. And so at the end of the day, when the magistrate indicated she could not stay late, I guess as a result of security issues in the courthouse, not at the request of either party, the magistrate ordered us back at 8 o'clock the next morning to continue the trial. That immediately presented the conflict that that's set forth in our brief, which is I couldn't be two places at one time.
How much notice had you had of the other proceeding that created?
The other proceeding had been set for approximately 6 months. So these matters had been, the trial date was in place.
Well, then let me ask you, when they set it for a 1-day trial, did you raise the potential conflict with the court? Must have had an idea that it was going to be longer than a day, no?
I anticipated that. In fact, at a pretrial conference that was raised, indicated that, that this can be done in 1 day, and the court said it was intended to stay until late to finish it. So, okay, if that's the way it was, there wasn't any need to file a proscriptive or...
So, quick question on that. Is that going to be in the record?
I don't know. I cannot answer that completely. I'm sorry, but I just don't remember.
Okay, that's all right. Thank you.
Okay.
Counsel, I wanted to make sure with the notice that was sent out about the date of the hearing, the trial was 1-day trial, you said.
Yes, sure.
But did it say and to be continued until finished or not?
No,
Any
it did
notice
not.
like that?
No, it did not. Not continued day to day. If that had been the case, under these circumstances, there would have been an appropriate motion filed. Nevertheless,
I just thought that might be standard verbiage.
in some courts it is, but in this particular instance it was not. In any event, the next day we showed up at 8 o'clock in the morning. I again moved orally for a continuance of the trial because I could not be two places at one time. I had a series of witnesses that were under subpoena in Lorain County for my trial that was supposed to start at 9 o'clock. The magistrate consulted with someone, I'm not sure who, and came back and said, your motion to continue this second day of the trial, despite it never being noticed for trial, is denied. And in response to that, I filed a handwritten notice of appeal to this court and presented it to the magistrate, and the magistrate concluded that she did not have jurisdiction at that point and then continued the matter. Ultimately, that appeal was dismissed because the magistrate never memorialized her decision in any event, and there's a serious question about whether or not that is in fact a final appealable order, no matter what. But that's a separate issue for a different day. Then the matter was reset for trial on December 27th, which would be, of course, 2 days after Christmas. And even though that's a week that lawyers customarily, at least many lawyers, don't work, I'm not speaking for all lawyers, I don't know about your honors, but many people try to take that last week off in the year. But in any event, I did not have any conflicts on that particular day. My client did not have any conflicts. We intended to proceed on December 27th. However, my client, who had successfully purchased a home and had it built for him in Tennessee, informed me approximately 3 weeks before the trial date that the closing in Tennessee, which is an in-person closing, unlike most closings in Ohio, needed to take place before the end of the year. The only day that was available, given everyone's schedule, was December 27th, the day of the trial. So I also had some professional obligations to complete my CLE requirements for that year.
Well, let me back up for a second.
Sure.
Regarding the closing that had to be in person, you're taking everyone's schedule into consideration, correct?
Actually, this was something that was imposed on my client. It wasn't something he was asked to do. He was told, this is the closing, this is the date, you must be present. And it is a closing, they call it a table closing, which is quite literally, you push the money across the table and you get a deed at that point, which is then immediately recorded. This is not done like in Ohio, which we're accustomed to, which is you have a third-party agent, an escrow agent, who receives funds, who receives the title documents, and then basically it's a simultaneous transmission. That is not the way it happens in the state of Tennessee, and as a result, I filed a motion to continue. That motion was immediately denied.
Counsel, my
Yes, sir.
understanding from the appellee, and I don't know what's in the record, obviously, but there is some evidence that closing had already been continued at one point.
Your Honor, the closing was previously scheduled, that's correct. And then because the builder was delayed in finishing the house, it's my understanding that in order to maintain the financing, the deal had to be closed by the end of the year. So we presented these documents, they are part of the record, the actual closing information, and this is not a contrived situation under any circumstances. So we presented those to the court, and without conducting any hearing, without any inquiry, our motion was immediately denied, which then put my client with a Hobson's choice. You either close on your real estate, or you fail to close on your real estate with all the financial consequences that result, or you fail to show up in court. So ultimately, he determined that he needed to close on his house. It was a big investment for him. And we asked the court to continue the matter. It was set for the whole week. So however many days it was going to be set, the notice said it was set on the 27th, 28th, and 29th, and 30th, if need be, of that week.
I would interrupt you just briefly and stop the clock, by the way.
Only because right now you've got 4 minutes, so you've got about a minute before you jump into your rebuttal time.
Okay,
All right?
thank you.
Okay, I'm going to start it up again.
So we asked for the court to schedule the matter on the 29th, which would allow him to get here from Tennessee and finish the case. We anticipated it would take 1 day and would give him an opportunity to testify regarding the allocation of parental rights and responsibilities. The court said no, and when we showed up on December 27th, I had no witness, but I was here and asked the court again to continue the matter just for 2 days.
Well, was the wife there?
Wife was there.
You said you wanted to call her in your case.
Well, I wanted my client, I had a strategy in this case. I wanted my client to testify first, and then I wanted to ask her some questions about what he was going to testify about. I did not have those facts yet in evidence to be able to inquire of her about that. That was the reason.
3 minutes.
So, okay, I'm moving.
You're just so you know, you're in that rebuttal time.
Okay, well, I think it's important to at least lay this out further.
That's fine.
The court ultimately then conducted an in-camera interview with the children without any other adult being present. Of course, we don't know what was said during the in-camera interview. Then the magistrate issued a decision designating mom as the primary residential parent, giving my client very limited parenting time, and also establishing a child support order. We then filed timely objections to this, preliminary objections. We asked for the record to be produced, all the testimony. We ultimately obtained the testimony. We ultimately filed the testimony. And then the court, I would submit, arbitrarily and capriciously denied our motion to supplement our objections, and because the record had not been filed within the time that the court believed it should have been filed, even though there was no order and there were multiple motions relating to this subject. We think that the denial of our continuance in this case denied due process and was completely an abuse of discretion under all the circumstances. My client was entitled to be heard with respect to the allocation of parental rights, and he was deprived of that opportunity without any reasonable justification by a magistrate who had already determined that she was going to push this case along no matter what, and irrespective of what the facts in the case actually were. I believe that that constitutes an abuse of discretion, and as a result, I believe that the court should reverse and remand this case for a trial solely on the issue of the allocation of parental rights and responsibilities, so that all victims can be produced. I'll reserve whatever.
1 minute and 23 seconds.
There we go.
15 15 minutes, counsel.
Attorney Steve Bailey from Marella Senior here. I think that this issue of abuse of discretion on the granting of continuance is an important one. But I have to say that in this particular case, I think there was overwhelming reason for the court to deny this appeal. And I want to make clear too, there was a lot of discussion during Mr. English's presentation about the original trial date and the things that happened that day and the next day when he had the trial in Lorraine County. I just want to make clear that none of that has anything to do with this appeal whatsoever. This is entirely about the second day of trial that was scheduled for December 27th. And Mr. English, in his brief, gave you a procedural history, which I adopted in mine as well. It is important, I think, to look at that procedural history to understand why this court wanted and needed to get this matter resolved. My client had been without child support for 18 months because the Tennessee court had declined to exercise any jurisdiction over the children. And so, consequently, all of her temporary support orders in Tennessee, of course, disappeared. So we had to come up here and file with appropriate actions. And Mr. English filed one, I filed one. We decided essentially it didn't matter which one we went with. And so we needed to establish a custody order here and to get a child support order. I would note that the motion that we filed asked for temporary child support, but the court never acted upon that. And that's in the record, you can see it. And so consequently, she was without support. I also believe, as I put in my brief, that it's a fair reading of the record in this case. It's a fair inference that you can make from the record in this case. That Gary Singer was very obstructive in trying to bring this matter to a conclusion. The very fact that after the first divorce was dismissed in Medina County, he went down to Tennessee and renewed his divorce down there, then attempted, all of this is in the record, then attempted to dismiss the divorce down in Tennessee and bring it back to Ohio. It is a reasonable inference that this motion to continue was just another Mr. Singer's delaying tactics, and I think the court saw it that way. One of you, and I believe it was Judge Carr, I'm not sure, asked Mr. English about the closing on his house, on Gary's house, having been continued before. It was. And that's right in the exhibits that they attached to their motion to continue. They attached 4, I think, or 5 exhibits. And they showed that the closing had once been set for October 15th. It was then changed to December 16th. It was then changed to December 27th. There's also the sales agreement that shows that that the closing would be on December 27th or such earlier date as may be agreed to by the parties in writing. And I think Judge Callahan asked, wasn't there an accommodation of everybody's schedule in trying to set this new closing? Well, that's not in the record, but it is logical in common sense. And so, in the final analysis, our court here had the choice of granting yet another continuance, having my client go, gosh only knows how many more months without child support, for the convenience of actually Gary Singer's builder, who wanted to get it done before the end of the year. And the timing too is strange because the court set this date. I'm not going to be able to pull this out of my head, but the court set this date shortly after the aborted attempt to try it the first time. And it was at least 2 months in advance that the court set this December 27th date. And, it wasn't, they weren't asked to continue it until, I don't know, 3 weeks before, something like that. I can't imagine if the denial of any continuance would be within the sound discretion of the court. I can't imagine that this one wouldn't be. So, that is basically what I have to say about that. Mr. English didn't get the opportunity to talk too much about his second and third assignments. I want to briefly talk about them. The second assignment has to do with the psychological evaluation. And here again, I made the point in my brief, and I believe it's a reasonable inference, that this again was Gary Singer trying to delay his responsibilities, because this matter had been before the court for a year and a half, and actually that's not true, because in the first divorce in Medina County, it had been in front of the court for 2 years, the issue of custody. And yet, in all of that time, nobody had ever decided that a psychological evaluation was needed. Suddenly, 19 days, I think, sticks in my mind before trial, maybe 23, odd number, I think. The father decides he needs psychological evaluation. And why? Because a deposition that he took of the mother revealed evidence that a psychological evaluation was needed, except that, as I pointed out in my brief, the record shows that the motion for the psychological evaluation was made before the deposition was taken. And so, consequently, that can't be true. Then finally, the issue of the in-camera interview without a guardian ad litem being appointed, I truly think, I used the word frivolous in my brief, and I probably shouldn't have done that. Out of collegialness, that's right. Collegiality, there you go. But it really is off the charts. I mean, there's no requirement in the statute for there to be a guardian ad litem in an in-camera interview, and especially when you're talking to children of this age. It happens all the time. I certainly don't think that's an abuse of discretion. So, all in all, I would ask that this court find that our court did not abuse its discretion in any of these matters, and leave this decision, albeit not the final appeal order this court wanted, standing. Thank you.
Thank you for your argument. Sir, were there any questions? No. Okay, thank you.
So I have 1 minute and 23
1 minute
seconds.
and 23.
Talk fast, Mr. English. Okay, yes, I will. Well,
You're
first
on
of
the
all, the idea of an inference that somehow we were trying to delay the proceedings by requesting a forensic psychological evaluation and by moving to, or for a continuance of a trial under these circumstances is a little beyond the pale, I would respectfully submit. There are a couple of facts that Mr. Bailey has wrong. There was not a situation where there was 18 months of no child support. The case in Tennessee was resolved in January of 2018. That's when the support ended, not 18 months before that or any number of months before that. And that's not the issue in this case. The issue in this case is whether or not we were deprived of an opportunity to present evidence, and it's clear that we were. And so, based upon that, I respectfully submit, Your Honors, that if you look at the facts and you apply the applicable law, and you see here that the continuance effectively deprived Mr. Singer of presenting any evidence, despite the fact that we were asking for a 2-day continuance, not months. We were asking for 2 days. We wanted to come in on a day that the court had set aside for this trial, December 29th, when Mr. Singer could be present, but instead that was denied. And I think that is unreasonable. And the reason that I raised the procedural history of the case with this magistrate is it gives you a flavor for her unreasonable behavior with respect to the handling of this case. Therefore, I ask you to reverse. Thank you.
Thank you very much, both of you, for being present today and for your arguments. The court will take this matter also under advisement and issue a decision in due course. And the clerk of courts will mail you each a copy of the decision on the day it is released. Again, we appreciate your presence and your argument. Now, the court will next be in